Good morning. So I thought we'd get on and talk about the first week's readings. The first part of this course pack is kind of exploring a little bit of just general history about how we got the Constitution. And so in 1776, the Continental Congress severed ties and issued the Declaration of Independence. After that, we had a brief period where we were under a different document in the Constitution called the Articles of Confederation. And then shortly after the Articles of Confederation, we see the Founding Fathers get together to adopt the Constitution. The goal of the Constitution is that it is the supreme law of the land. There are 7 different articles to the body of the Constitution. The first 3 deal with the 3 main branches of government and the separation of powers between those branches of government. So Article 1 deals with Congress, Article 2 deals with the President, and Article 3 deals with the federal courts. For our purposes, that one is the one that we're going to be spending time on. Articles 4, 5, and 6 all relate to federalism, the rights and responsibilities of state governments, and the process of amending the Constitution. The Constitution has been amended 27 times, but the first 10 came together in the Bill of Rights. And those are where we're going to be spending our time with the addition of the 14th Amendment, which was adopted in the post-Civil War era. You can follow the link to the text to the Constitution if you'd like to read through. That's not going to be required for this class. But in each relevant amendment we're going to be studying will be the first part of each module subsequently. So the next module, the first amendment we'll cover will be the 4th Amendment, and the first part of that module is the actual text of the 4th Amendment. Congress has the ability to make some structural changes to the federal judicial system, and they have done so slowly, but there is a 3-tiered structure to the federal court system. All things start off in the trial court or the district court, and then there is courts of appeals, and then there's the United States Supreme Court. Decisions of the United States Supreme Court are binding on all federal courts and state courts when the item has been incorporated to the state. Okay. There's a great map kind of detailing out the 13 appellate courts, how we're kind of structured, so you can see that here in Indiana we are in the 7th Judicial Circuit, the 7th Circuit Court of Appeals, along with Wisconsin and Illinois. There is a lot more information there about federal courts, but we are going to be spending the bulk of our time this semester with the United States Supreme Court. In the United States Supreme Court, there are 9 justices. There's 1 Chief Justice and 8 Associate Justices. There is this great scrolling through here that details exactly who the justices are and a little bit of biographical information. So our current Chief Justice is John Roberts. He's been Chief Justice since 2005. With Justice Kennedy retiring and the addition of 2 new justices in the last 3 years, Justice Roberts has become kind of a central figure in managing the role of the court. Justice Thomas is the longest serving justice on the Supreme Court. He had a controversial appointment in the Supreme Court because someone did come out and accuse him of some sexual harassment. He was ultimately confirmed to the court. After that, there is Ruth Bader Ginsburg. She is the 2nd female Supreme Court justice in the history of the United States Supreme Court. And she, some of you may have heard of her for the nickname RBG. She's a very outspoken advocate of ending sexism. Justice Stephen Breyer is one that not many people have heard of. He is a law professor, and he's written some books about constitutional interpretation that are really engaging and interesting. Justice Alito was nominated by George W. Bush and has been on the court since 2016. He is largely kind of quiet and keeps to himself. He's not out in the spotlight very frequently. Justice Sotomayor was appointed by President Barack Obama, and she is the first Hispanic and Latina justice to ever sit on the Supreme Court. She was born in the Bronx, but her parents were Puerto Rican, have Puerto Rican heritage. She was also a former prosecutor for a long time. Justice Kagan was also appointed by Barack Obama in 2010. She is the fourth female justice. She's a former dean of Harvard Law School and served as Solicitor General, which is the United States attorney that represents the federal government before the Supreme Court exclusively. Neil Gorsuch was appointed by President Trump. He has a long academic history. He's written some books, and he's extremely interested in the idea of assisted suicide and how that relates in to some of the other courts' doctrine and jurisdiction. And our most recent Supreme Court justice, who has just marked his, or will soon mark his 1-year anniversary in the Supreme Court, is Justice Kavanaugh. So, and Justice Kavanaugh, if any of you follow the news will know, he had a very contentious confirmation, but he did ultimately make it through the process. He is marked kind of right at his 1-year anniversary, so we don't know a lot about him as a justice or his jurisprudence, his style, and the things that are going to be the most important to him yet. He just hasn't been on the court long enough. Okay, so the federal court systems work on this principle of stare decisis. That's how you say that, stare decisis. We can also kind of substitute in this idea of precedent down here. That means the same thing as stare decisis. And this idea of precedence is that once the Supreme Court or those federal appellate courts make a decision, in all similar cases, they should reach the same outcome. That is with the purpose to ensure that there's kind of stability in the law and constitutional interpretation, and that the system remains legitimate, that you can predict outcomes for similar cases by previous cases. Now, there's always every year there's a novel opinion, things don't work out, or we can distinguish sometimes. Well, this case is not quite the same as this one over here because of these factors, and we should that means we should get a different outcome. But by and large, courts do rely on this doctrine of stare decisis to keep some stability in the federal court system. So as we read this semester, we are going to see the courts kind of build upon their past cases with each subsequent case and as new things come up. So with the Fourth Amendment in particular, we're going to see them building on cases from the 60s about blood draws after car accidents or after arrests for convictions to, we're going to see them kind of apply those same ideas later on to the use of thermal imaging equipment and to cell phones. And then there's a series of cases working through the federal court system right now kind of dealing with drones and how drones are impacted by the Fourth Amendment and your right to have to be protected against unreasonable search and seizure. So this principle of stare decisis is really important. So, there are times where the Supreme Court will overrule itself. So, in 1986, the Supreme Court in Plessy v. Ferguson announced this separate but equal doctrine, which essentially meant that states in the federal government could separate people based on race and ethnicity as long as they provided equal accommodations. So this allowed Jim Crow laws to thrive and flourish, and it essentially was a new type of slavery for people who were non-whites. And that doctrine ruled until 1954, when the Supreme Court explicitly overruled it in Brown versus Board of Education. And we're going to look at both of these cases towards the end of the semester. So when the Supreme Court makes a mistake, sometimes they do overrule it. And that is part of why the new additions to the Supreme Court are so controversial right now, because abortion is an interesting issue that people have strong opinions on, and people hope that maybe this will be overruled or changed one day. So that's part of why who gets on the Supreme Court matters so much. Okay. The inner workings of the Supreme Court, we know the basic process, but we don't get to hear much about their day-to-day. This video kind of gives a walkthrough of what it's like in the Supreme Court, and is really interesting, so I encourage you to look through it. Justices have control over their docket. The Supreme Court hears 150-ish cases each year, and they write an opinion. The court, whoever's in the majority, writes one opinion. Other justices sign on. If justices disagree, sometimes they'll write a dissenting opinion. But that is not the main outcome. After justices write these opinions, there's all these mechanisms to kind of deal with how they're deciding things and why they're deciding these things. There are two predominant classifications for justices, either as a judicial activist or a justice who believes in judicial restraint. I don't know why I highlighted that. I wasn't touching anything. Judicial activism is defined generally as this idea that the protection of individual rights and liberties is an important job of the courts. So judicial activism looks at expanding the Bill of Rights in the 14th Amendment to include current practices like same-sex marriage, for example. Judicial restraint looks more at that judges should not really expand policy, and they should defer to other branches of government. So the judges who dissented in Obergefell v. Hodges, which was the case that legalized same-sex marriage, did so on the grounds that each state should have the right to define marriage for its own boundaries. Now that was the losing opinion. The judges in the majority engaged in some judicial activism and defended that individual rights and liberties under this idea of equal protection and due process. So if we're going to allow some groups of people to get married, the Constitution under equal protection demands that we not draw arbitrary classifications or random classifications. Okay, so those are kind of two main schools of thoughts. Most justices belong to one or the other, where they tend to either defer to the states and federal government, or where they think that the role of the court is to advocate for and protect individual liberties. Beyond that, justices, there are numerous examples of kind of how this works. So if you're a little shaky, go ahead and read through and then let me know. The justices, frequently though, we see relying on kind of judicial activism or restraint, and then relying on stare decisis, so talking about past cases and how they're similar or different. So as we kind of work through this first chunk of readings, those are kind of some really big picture points that I want you to think about. If you have any questions, if anything's not clear, let me know. You can email or stop by office hours, or we can set up a WebEx, which is essentially a Skype. Okay. I hope you enjoy this first week of readings from the course pack. and let me know if you have any questions. Otherwise, have a great rest of your day.